Good morning, everyone. I see we still have people joining, but we want to get started and be mindful of everyone's time commitment. Good morning. My name is Randy Kochman. I'm the chair of the employment group at Call Shots. We are thrilled to have you with us today to talk about employment issues as we're in week, I believe, 6 of the COVID pandemic. Most importantly, we hope everyone out there is safe and sound and your families as well. And we thank you for joining us, and we hope this will be helpful to you. Just to give you a little overview of what we're going to do today, we will be here for you from until noon. We have 3 speakers, myself, my colleague Jamie Claire, and Marissa Mastriani. Jamie is going to speak about the WARN Acts, and specifically he'll highlight the recent changes to the New Jersey WARN Act, which came out on April 14th. We know a lot of you out there are affected by large layoffs and furloughs and whatnot. He's going to bring us all up to speed on what we need to know about that. And Marissa is going to go over the very technical leave laws and how they interact with one another in the Tri-State area, New Jersey, New York, federal Families First Coronavirus Response Act, and the CARES Act, and all of that, the new paid sick leave and family leave acts on the state level. And then I'm going to talk about, I'm hoping it's a little hopeful, we're starting to hear about going back to work. And what does that look like, and what do we need to know? And I'm going to end us hopefully with a little optimism about what it will look like when we go back to our physical workplaces. What are the rules that we need to be aware of as we prepare to do that and as we actually do that? So that's a brief overview of your morning. We do know that we've already gotten some questions, and we know we're going to get additional questions. A word on questions. We will do our very best to answer them as they come in or when appropriate. A lot of questions are very fact specific, and we simply can't do it on this in this forum, but you're welcome to reach out to any of us separately. And the questions that are more easily, addressable and that a lot of people have, we will do our very best to take. So I think that's it for me. I'm going to hand it over to Jamie Claire, who will speak with us about the WARN Acts. Thank you, Jamie.
Hi, good morning, everyone. And echoing Randy's sentiments, we're at home because we have to be, and we wish you all well. We are here to work with you during these difficult times in this department and the employment law department and other departments at Call Shots. We've been very busy with landlord-tenant issues, with corporate issues, tax issues. So please feel free to reach out for us. If you need us, we're here for you. We all hope to be back soon, of course, in this time of COVID-19, which is a strange new world. I keep thinking of the John Lennon song, "Nobody Told Me There'd Be Days Like These." And it's certainly true. I didn't expect to be forced quarantine or sheltering in place. And at this time, we've seen an unprecedented uptick in applications for unemployment benefits. And simultaneously, we've seen an uptick in applications for small business administration loans and the Paycheck Protection Program loans. Please see the Call Shots website for blogs in corporate, tax, real estate, and employment for information regarding the various programs and loans available. Everyone is hurting from this pandemic. No one is immune, employees and employers alike. And as Randy said, pardon me, with mass layoffs and some plant closures, those generally trigger the WARN Act at the federal and state level. The states have many WARN Act notice requirements in addition to the federal WARN Act notice requirements. And I see a question here already. Not every state has many WARN. New Jersey and New York, yes. Connecticut and Pennsylvania, no, although I know Connecticut has a plant closure notice and a business sale notice act that are not WARN acts, but please see those statutes for the requirements of notice in your jurisdiction. What is WARN? It's the Worker Adjustment and Retraining Notification Act. It protects workers and their families and their communities by requiring employers to provide advance notice of covered plant closings and mass layoffs. What kind of notice under the federal act? It's 60 days. Who gets the notice? Affected workers or their representatives, including labor unions. And there may be additional notice requirements under collective bargaining agreements. The state dislocated worker unit and appropriate units of the local government. So check your statutes and your checklists. Each state varies. Pardon me. Employees entitled to receive WARN Act notice include hourly and salaried workers, as well as managerial and supervisory employees. So the coverage is broad. Federal WARN Act notice requirements generally apply to employers with 100 employees, excluding part-timers. And they're triggered by layoffs of 50 employees who equal 30% of the active workforce or 500 employees. Federal WARN has not been amended due to COVID-19. The New Jersey WARN Act, which is known as the Millville-Dallas Air Motive Plant Job Loss Notification Act, that's a mouthful. That's the New Jersey Mini WARN Act, and it requires covered employers to provide written notice 60 days before terminating 50 or more full-time employees within a 30-day period. If the termination is the result of a mass layoff, the law only applies if either it affects 500 or more employees that are full-time, or the affected employees represent at least 1/3 of the establishment's full-time workforce. So how does that apply to you, businesses in New Jersey? You really need legal advice to determine if you are subject to WARN Act notice requirements and what that notice should be. We're here to help you. Again, Randy mentioned New Jersey WARN was amended in January 2020, and again just last week in April 2020. Please see our website. Again, we have an employment law blog with details of the amendments. In short, New Jersey now requires 90 days advance notice. It's the first state in the nation to require employers to pay employees 1 week of mandatory severance. It includes full-time and part-time employees now in the employee headcounts and other expansions. It's really the most comprehensive and expansive WARN Act in the states now. But there is some good news. As I mentioned last week in April, New Jersey WARN was amended again. And under the amendment, the effective date of the New Jersey WARN Act amendments that I just mentioned have been delayed. So the effective date of the amendments are delayed now from July 19, 2020 to 90 days after the governor's stay-at-home executive order expires. So events that trigger New Jersey WARN will not be subject to the tougher amended state law until a to-be-determined date after July 19, 2020. Well, I see another question here. Does COVID affect New Jersey WARN? And the answer is yes. Mass layoffs due to COVID are not covered by New Jersey WARN now. That is because the definition of a mass layoff has been amended to exclude layoffs that occur due to a national emergency. This means layoffs due to a national emergency, including COVID, don't trigger New Jersey WARN. Before this new amendment, the national emergency exception only applied to a termination of operations. I should add that the change is effective retroactive to March 9, 2020. So last week's change is retroactive so that COVID layoffs that occurred on or after March 9, 2020 are now excluded from the definition of mass layoff. In New York, they have not suspended Warren Act notice requirements at all. They require 90 days advance notice of a plant closing or a mass layoff. And again, the act in New York is triggered by a mass layoff, among other things, meaning a workforce reduction other than a plant closing that results in an employment loss lasting longer than 6 months at a single site of employment during any 30-day period for at least 250 employees or 25 employees if they comprise 33% of the workforce at that site. All New York employers with 50 or more full-time employees located in New York State, not including part-time employees, must provide the notice. So New York businesses forced to close due to COVID, including as a result of government mandated closures, must provide the notice as soon as possible and identify the circumstances necessitating the closure. There are forms available for you on the New York Department of Labor website. I encourage you to go there. The notices also must include, and that's New York and New Jersey, they must include information about unemployment insurance, job training, and reemployment services for which the affected employees may be eligible. Model language, again, for this notice requirement, again, is included in state regulations and DOL websites. Furloughs, which are mentioned at the top of the slide here, they're not defined under the Warren Acts, but generally take them to refer to layoffs of employees with expectations of rehiring those employees within 6 months. So our New York employer clients have come to us and they've asked, well, if I expect to hire employees back within 6 months, do I have to give Warren Act notice? We've been advising them that if they expect to hire the employees back within 6 months, a traditional Warren Act notice is not required. They are required at the time it becomes reasonably foreseeable that a furlough or layoff will become permanent, or the extension of a furlough beyond 6 months will be required. I'm just going to move along to unemployment benefits because, as I said, we've seen an unprecedented number of applications among our employer and employee clients of unemployment benefit applications. I'm going to sound like a parrot here, but check your DOL websites regarding calculation of unemployment benefits. And know this, the CARES Act, or the Coronavirus Aid, Relief, and Economic Security Act, boosts unemployment pay for a few months now and extends regular benefits through the end of the year. So, of course, this has helped employers whose revenues have been shrinking and employees who have been laid off or furloughed. Our experience has been that employees should apply for state benefits first and then the supplemental benefits. The CARES Act has built into it what's called the Pandemic Unemployment Assistance, or PUA, and that provides unemployment eligible workers $600 per week through July 31 on top of their state benefits. It also allows them to collect state benefits for up to 39 weeks, which is up 13 weeks from the 26-week maximum most state programs provide. The Department of Labor websites, particularly in the unemployment area, are very busy. Persevere. We know that there will be relief. You just have to persevere. There are expansions in the CARES Act for unemployment benefits to cover many employees coronavirus-related scenarios that were traditionally left out for unemployment benefits. So self-employed, independent contractors, freelance and gig workers, they also have an opportunity to collect unemployment benefits under the CARES Act. Note too that the New Jersey Work-Share and Partial Unemployment Insurance program exists, and you just need to submit a form through the New Jersey Department of Labor website to take advantage of that. I saw an article in the Wall Street Journal this week that spoke to some employers need to increase pay to keep employers coming into work in essential businesses, because those same employees can earn more staying at home with their state unemployment benefit coupled with their CARES Act unemployment relief. So some employers are actually increasing pay to deal with that scenario and to keep their employees coming in. I just want to say in closing, we will all make it through this. It's just going to take time. There are programs available, there are monies available, and you should take advantage of them. So I'm going to now turn the program back to Randy, or I'm sorry, I'm going to turn it now straight to Marissa.
Thank you, Jamie. Good morning, everyone. It's a pleasure to be speaking with all of you today, although I wish it were under much better circumstances. First and foremost, I hope all of you guys and your families are safe and healthy. Like Jamie and Randy said, we will get through this, and we are definitely here for you. We've seen a ton of questions come in already. We can't possibly address all of them in this, but please feel free to reach out. So I am going to jump right in, and I'm, like Randy said, I'm going to be talking about the FFCRA, which is the Federal Families First Coronavirus Response Act, which provides for paid leave in certain circumstances, as well as the New York and New Jersey state responses to the pandemic, as far as employee leave goes, and different employee benefits available when an employee can't come to work, and gives them some sort of benefit there to recoup some pay. So for the FFCRA, it went into effect very recently, April 1st, and it's very rare that the federal government actually passes a leave law. So we know we're in some uncharted territory here. The law is temporary, so it only provides for leave benefits to employees through December 31st of 2020. I guess remains to be seen if maybe they'll extend it or not. Hopefully it's not necessary. It applies to all employers that have less than 500 employees. And the good thing about it is it provides employees with benefits because the government recognized that, something needs to happen here. The laws aren't sufficient enough to respond to this pandemic, because people are going to need to be out, whether it's for themselves or for their family members. But it also provides employers with some benefit too, because any money paid out under the FFCRA, you can get tax credits for later on. So long as you abide by all the requirements of the law, and I'll talk a little bit about the documentation requirements you'll need to submit to the IRS. The IRS has published guidelines on this, so I highly recommend all of you taking a look at that as well on the IRS website. So there are really two types of leave provided for under the FFCRA. I like to think of it two different buckets. So the first bucket of leave is paid sick leave to employees. And that's where an employee will get 2 weeks of paid leave for 6 covered reasons. And we have to be careful. We have to fall within one of those 6 reasons in order to later claim a tax credit for the money provided to employees. So a regular full-time employee will get 80 hours of paid sick leave. Or, if you have a part-time employee, it's whatever the 2-week average is. I do want to note, though, because I've run into this a bunch with clients already. So, of course, in response to this pandemic, a lot of clients have cut back on employees' hours. And full-time employees are no longer full-time anymore. The act says that when looking at how much hours, to calculate for 2 weeks, we have to be careful. It's a 6-month look-back period. So even though an employee is now just working 20 hours a week, the 20-hour-a-week mark is not the only measurement here that we have to take into account. So for the paid sick time, there are a bunch of reasons someone can take it. And, it's kind of set up in 2 different categories. There's reasons pertaining to themselves. So that's where a healthcare provider recommends that they stay quarantined because they possibly may have COVID-19, or they have COVID-19 symptoms and they're seeking a diagnosis from a medical provider. And then the other type of leave is for when someone takes paid sick time to care for a family member. So that's when a family member has COVID-19 and needs to be quarantined, or a child, like a lot of Americans are in this boat here, their school is closed or their daycare is closed. So when a parent needs time off to take care of their child because of that, they could also use paid sick time. So when an employee uses paid sick time for themselves, they get their full pay for the day up to a maximum of $511 per day. And when an employee takes time for a family member or to take care of a child, they get 2/3 pay for that day, up to $200 a day. And this paid sick time is available immediately upon hire. An employee doesn't have to have worked for the company for X amount of days to qualify. So the other type of leave provided by the FFCRA, the other bucket here, is expanded FMLA benefits. So this is much more restrictive in the sense that an employee is only eligible for expanded FMLA benefits to take care of a child when their school is closed or their daycare is closed. There is a eligibility requirement here of the employee working for the employer for at least 30 days. During the expanded FMLA period, it's 12 weeks of paid leave. The first 2 weeks are unpaid unless the employee wants to use their paid sick time, for example, the other bucket that I talked about earlier, or they want to use any PTO under company policy. They can get pay for those first 2 weeks. And then the remainder of the 10 weeks is paid at 2/3 pay, up to $200 a day. And as far as the pay goes too, another issue, kind of like the hours requirement I was talking about. In order to calculate someone's full pay or regular rate for the day, there is a 6-month look back period. So if an employer has cut salaries recently, you can't just use the most recent salary number. You have to average out what the employee made over the last 6 months to figure out what they're entitled to be paid under the FFCRA. And a huge note here, because I've got a ton of questions about it. An employee is only entitled to take FFCRA leave, either the paid sick time or the expanded FMLA benefits, only when they are unable to work because of one of the covered reasons. So an employee that has to take care of their child because they're home from school, but can still work remotely from home, is not entitled to FFCRA leave. I mean, of course, as an employer, you can always decide to be more generous. But if you are going to decide to be more generous, just understand that you're not going to be able to claim the tax credits later on. So, and also I've gotten a lot of questions too. A lot of businesses have been shut down in New York and New Jersey because of the executive orders issued by the governor. So if an employer is shut down, employees aren't entitled to FFCRA leave because there is no work available to them anyway. It's not like they're absent from work only because of the covered reason. They're absent from work because of the shutdown. And of course, the employee recourse there is they can apply for unemployment. So like Jamie had mentioned. There are some exemptions though, I do want to note under the law. So the first one is for healthcare providers. And the DOL, which I highly suggest all of you go on the US DOL website. There is a ton of FAQs on the FFCRA and also government just issued some regulations on this. But the regulations define healthcare providers very broadly. So really anyone that works for a doctor's office, a hospital, a nursing facility, a lab, pharmacy, anyone working for those types of companies do not have to be given FFCRA leave. Again, an employer can choose to do so, but that they are not required because those employees are exempt. Emergency responders are also exempt, and there's also the small business exemption. So any employer that has less than 50 employees may be able to claim that, hey, I can't comply with the FFCRA because this is going to jeopardize the viability of the business as a going concern. And there's also guidance on that online as well as what that means and what you would need to show. And I did notice that we got a question about intermittent expanded FMLA leave. An employer can permit employees to take intermittent leave, which means that they only have to take half a day of FFCRA leave instead of a full day, but an employer is not required to do so. So every kind of situation there depends on the circumstances. So please feel free to reach out if you have questions about that. And there's also a DOL notice that was issued by the government not too long ago that I suggest you email out to all of your employees. I mean, it is required that you post it in the workplace, but most people are not physically in the workplace anymore now. So I suggest emailing or maybe hosting that on a company intranet to make sure you're in compliance with the requirements there. Another kind of frequently asked question I get about the FFCRA is, how does it work with our company PTO policy? So FFCRA leave, whether it's paid sick time or expanded FMLA, is in addition to whatever the company PTO policy is. So even though your PTO, you give people 80 hours a year anyway, that doesn't matter. They still get the 80 hours of paid sick time if they qualify. All right, so moving on to the state responses here and how it all interplays together. So New Jersey and New York, both of them have passed legislation rapidly to respond to the crisis. I'm just going to go over them very briefly because we are under time restrictions. But as far as New Jersey goes, there's a really good chart issued by the New Jersey DOL with a lot of different COVID scenarios. And it's like a chart that'll say, oh, in this scenario A, an employee is entitled to unemployment, or they're entitled to paid sick leave under the New Jersey law, or this or that. It's a great chart for you guys to refer to. The New Jersey has amended its own paid sick leave law to expand the types of covered reasons an employee can use it. So employees can now use New Jersey paid sick leave due to the closure of their child's school and needing to take care of their child, or when a doctor recommends that they self-quarantine because of fear of having COVID-19 or actually having it. So employees can now use their paid sick time in New Jersey for more reasons than they were able to before. And last week, Governor Murphy also amended the New Jersey Family Leave Act. And that act it's similar to the FMLA, but not entirely identical. That act provides for 12 weeks of unpaid leave to New Jersey employees over a 24-month period. So now employees get this 12 weeks of job protected leave for COVID-related absences. And New Jersey also amended the paid family leave insurance law and the temporary disability benefits law so people who are out of work because of COVID-19 related issues, whether for themselves, which would be disability benefits, or for an employee, their family member to take care of them, they can now apply and be eligible for temporary disability benefits, which is X amount of dollars per week, and paid family leave insurance benefits, which is 6 weeks of paid benefit. And starting in July, that benefit goes up to 12 weeks. So there's a lot available for New Jersey employees there. And so New York had done similar things. New York on March 18th, very quick response again from New York. Maybe that's, they're obviously, fortunately, the hotbed of the pandemic here. The state passed a quarantine leave law, which provides for job protected leave to employees in certain COVID-19 related absences. So whenever an employee is quarantined due to government order or due to a healthcare provider, like a Department of Health order, then they could take protected quarantine leave under New York state law. The amount of leave depends on the size of the employer and the profitability of the employer. So for example, employers with less than 10 employees making less than $1 million profit per year, they are just get unpaid quarantine leave through the time that the quarantine order lasts. However, employers that are bigger, like 100 plus, employees have to get 14 days of paid quarantine leave. And again, it's all job protected. So an employee has to be reinstated after they take this leave to their either the same job or a job that's substantially similar in all employment terms. In the New York law, this quarantine leave law does, address the fact that the FFCRA exists, and it says that it works together with the FFCRA in the sense that an employee, it's concurrent to the extent that the laws are the same, but a New York employee will get the benefit of the New York law where it's more broad than the FFCRA. So a New York employee, theoretically, depending on the circumstances, could get more paid benefits under the New York law than the FFCRA in certain circumstances. New York has also expanded its disability benefits and the paid family leave benefits available to employees there to address, kind of like New Jersey, employees that are out of work because of COVID-19 issues to take care of themselves or their family can now apply for temporary disability benefits or paid family leave benefits. And also as an ending, to get a quick note on this, it's not a COVID-19 specific law, but New York also just passed a statewide paid sick leave law, which goes into effect September 30th. So it's coming up on us, and has, depending on this, again, the size of the employer, it depends how much time you actually have to give to people. But it's a little different because New York City had a similar law, which provides for up to 40 hours of paid sick time to employees. This New York law for employers of over 100 employees provides for 56 hours of paid sick time. So I highly suggest you guys, all New York employers, take a look at their policies and to get ready for that law. Employees have to begin accruing starting September 30th. They don't actually get to use the time until January 1st of next year, but still they have to be accruing. So that's just something to keep in the back of your mind too, as all of this kind of works together, and employees understand their rights and are watching the news just like all of us, and realize, what they are entitled to under the law. And so with that being said, I am all done on my topics, and I know we might have some time for questions at the end. I want to pass it up back to Randy, who's going to talk about workplace safety issues and employee accommodation issues, which I see we're getting a lot of questions about, as well as some forward-looking considerations as to how to begin rehiring your employees when the restrictions start to get lifted. So thank you.
Thank you, Marissa. Great. I know there are a lot of, Marissa's area is a very technical area, and I know there's a lot of questions about unemployment. We've spoken on this many times over the last month, I guess, and there still seem to be a lot of questions. I'll just touch on, one, which seems to be a concern out there is, employees want to stay on unemployment, they make more. What do we do about that? First of all, I would say to that, it's not all, obviously it depends on what the employee earned, whether they make more or not. But if they are offered a job to return to, theoretically, they shouldn't continue on unemployment. So if you're ready to bring your employees back, you want to communicate that in writing. The job is, we're here, we're open, and notify the state. And the other thing I would say to that is this is temporary. Right now, as Marissa said, this is through July 31, the pandemic unemployment assistance, the $600. So it's not going to be that these rates will go back. Maybe it'll be extended, but at some point, the idea of unemployment is a safety net to help people who are out of work through no fault of their own It is not to encourage them to stay out, so they generally make less. And I think the idea of the PUA was that this is a pandemic, that certainly, we don't want people starving or whatever. So government felt it was important to supplement those rates. So that's my thoughts on the unemployment, because we do get a lot of questions on that. So I want to shift gears a little bit and talk about hopefully a bright spring and summer, and everyone trying to get back to normal. We know in the Tri-State area we may be toward the end of that, but we have to plan. So all of you employers out there, if you haven't already done so, you should have plans in place. These are multifaceted plans. So your facilities manager, your HR, it should be a cross section of your organization planning for return to a physical space, or if you are one of those companies that has been shut down, reopening. If you're in retail or the hospitality industry, what does it look like to reopen? If you are a company that's essential and you're working with a skeleton crew, what does it look like when you get back up to scale? So the first thing is your physical workspace. And for that, I want to remind everyone to follow the CDC guidelines. OSHA and all these agencies are working together, and the CDC is considered the gold standard on what we should and shouldn't be doing, and all these agencies are going to rely on the CDC. So you want to be checking the guidelines regularly, and OSHA as well. For your physical space, we know that OSHA requires a safe workplace. It's a duty of the care standard, and OSHA has provided already industry-specific guidance to retail, packaging, delivery, and manufacturing, and they promise others. So various industries are going to get specific guidance on what your facility needs to look like. Do you need plexiglass? Grocery store, who still goes to the grocery store? They have those one-way lanes. The markers on the ground about the 6 feet. So all of those are coming from OSHA. So you want to be aware of that in your organization. The next thing I want to talk about, aside from the physical space, is the issue of employees. And what are we going to do with employees as we reopen? A lot of businesses, you're teleworking. So what happens when you're allowed to go back into your space and you want to bring employees back? My overriding theme on this is to use caution and be flexible. Because I think the rules that we used to assess these things in 2019 just don't apply here. So for the legal backdrop, just so everybody understands that we're working under, is the EEOC is the Equal Employment Opportunity Commission. It's a federal agency, and their job is to ensure that there's no discrimination or harassment in the workplace. And every state has a counterpart. But the EEOC has a website, eeoc.gov, and the good news is they provide a lot of guidance, and they tell you exactly kind of their position on these things. A lot of times they're forward, they're ahead of the courts, but they will tell you exactly what they think. If you Google and if you have time to read, they have a pandemic assistance program, which is, it was originally prepared for H1N1, which was technically a pandemic, but not as full-blown as this, of course. But it was this pandemic preparedness in the workplace, and the ADA guide, that's the title, was updated in March. So I encourage you, it was nicely done because what they did was all the additions that are COVID related are in bold. So they tell you, yes, you could take temperatures of employees, which in normal circumstances, you cannot just go around and take temperatures. Now you can, it's in there, look at question 6, 7, 8. And so that begs the question, just to go back for a minute, on your physical space, when you're preparing your physical space, what supplies do you need? Are you in a workforce that you need to get your order in, like the federal government, for your PPE? Do you need temperatures, thermometers? Do you need masks? Do you need mats? Do you need to reconfigure desks? What exactly, if anything, do you need to do to your physical space before you reopen? If you have clients coming into your space, how are you going to deal with your clients? Are you going to ask them to sign in? Are you going to ask them those 5 questions about how they feel? All of this needs to be really planned out before you actually open the door. And this is, again, governed by what we're allowed to do. And so the legal backdrop is that normally, we have an ADA, Americans with Disabilities Act, which provides a lot of protection to employees in terms of privacy. We have privacy in our medical health condition, and an employer cannot just go around asking questions and taking tests with certain rules, of course. Those rules have been relaxed because we are in a pandemic. And so the law recognizes that there's this balance between employee privacy rights and the obligations we have to one another. And for any lawyers out there, you may have heard it, it's called the direct threat standard. So of course, if you're an employer who feels that an employee may be a direct threat, maybe it's someone who has a violent background, you have more leeway dealing with that employee than you do with someone without such indicators. And so right now, because we're in a pandemic, we may all be a direct threat to one another. And so because of that background, because the direct threat standard is met, the employer has more leeway. What does that mean? It means you can take temperatures. It means you can ask questions about employees and their symptoms. It means that you follow the CDC guidelines. So if you know an employee has had COVID, depending on the timing, you can have them give you a test. Give you their symptoms. You can ask them questions. You can take notes before you return that employee to the workplace. Fitness for duty test, you can certainly require those of people who have told you that they've been sick before they come back. We have to, again, getting back to my flexible point, our healthcare workers are inundated. So it may not be so easy to get a fitness for duty note that you ordinarily could get easily. We have to be flexible about those kind of things. So if you're really nervous about it, maybe you make that employee continue to telework for a few more weeks if you can't get that note. Big point I want to discuss is reasonable accommodations. So the concept here is that we do it all the time. If you have an employee who needs an accommodation, whether it's a physical accommodation, they need if they have trouble hearing or trouble seeing, they need a device on their computer, or if they're going through treatment and they need a flexible schedule. These are all reasonable accommodations that an employer has an obligation to discuss and explore with an employee. The EEOC has been very clear that in this pandemic era, that obligation is even more heightened. So we have an obligation as employers to be flexible. And this is the tricky thing, every situation is different. So when we reopen and, let's say you want flexible schedules or you've worked it out how you want people to come back, I know, because I'm already getting these questions, and we will only see more, there will be employees who do not want to return. They are nervous. They may not be sick. They may not have anyone in their family sick. They may not have symptoms, but they may say to you, I'm not coming back. Okay, why is that employee not coming back? Is that worker an older worker? Is that worker on some kind of medication that makes him or her immunocompromised? These things, and if that's the case, the reasonable accommodation test is going to kick in. So you are going to have to deal with those employees and try to work out, okay, is this an employee who can telework? Is this an employee who maybe is just worried about the commute and we can take them out of public transportation? Maybe we can stagger the schedule so that the employee is not exposed to anyone. Creativity and flexibility is going to be the key here. And I would caution anyone to not just take a response that, well, we're reopened, come back. That's not what the EEOC is telling us they will be looking for, and that's not the analysis that we have to do. Those are challenging because they're going to be fact specific. And the question comes up, we call it the fearful employee question, where, may not be an employee who's sick, but they're just fearful. And everyone may be different. They may be fearful for different reasons. And that also impacts unemployment. We always get the question, Well, if that employee just doesn't want to come, do they still get unemployment? In general, the answer is probably no. If they are voluntarily not coming to work, that doesn't meet the test for unemployment. But the tricky part is it may not be voluntary. It may be that they feel a constructive, prevention from working because of their medical condition. And we're going to see how the state deals with those claims, whether they find those are unemployment compensation qualifying or not. The other thing I want to point out to everyone is the EEOC made a point of highlighting that mental illnesses and psychological issues that a lot of people are going through now with this are included. So, if it's someone who had a pre-existing condition and it's been exacerbated, this reasonable accommodation standard still applies. Same analysis. Okay, a note on confidentiality. All of these inquiries that I'm mentioning, the temperatures and the questions and the fitness for duty exams, these are all medical documents. They are required to be kept in a separate file by the ADA, so separate in your personnel file. The idea is that they're not so easily accessible. And all of these documents are included in that. So if your HR person is taking notes, if you keep a temperature log at some point, all of those go into your confidential records file. So keep an eye on that. You're certainly able to ask for these records. There's no problem there. I just want to make sure everyone's careful about how you're handling those records. Restoring employees and staying away from additional problems on discrimination and harassment. Let's be careful here. When we reopen, again, for those stores that are, I say stores, retail that's closed, or restaurants that are closed, or other travel-related industries that just, had to lay off a lot of employees at a time. Let's be careful when we bring back. Now, if you're going to reopen and everyone comes back, great. If you're bringing a portion of your workplace back, you need to be very careful about how you do it. You don't want to open yourself up to any discrimination claims. You're bringing all the young people back. You're bringing all the men back, whatever it is. It has to be, justified by a business need. So maybe it's a particular division that's ramping up, and those are the people who come back. Same thing applies with, if we're going to be restoring pay cuts or benefits or anything like that. Just be careful in how those projects are rolled out. And of course, with all of this, we employment lawyers love to talk about policies and procedures. You want to make sure everything's in place. Just going back for a minute, a note on the reasonable accommodation. It may be, like I said, all the physical spaces, but it may be continuing to have people telework. So you want to have those telework policies in place. Like, I know this kind of came up quickly, and a lot of companies, some were set up better than others for teleworking, but if you don't already have a policy, you should. So how are you dealing with it? What are your hours of work? How are you dealing with wage and hour issues? Are you having people who are non-exempt punch in, punch out? How are you keeping track of those hours? Expenses. People have more expenses when they're working from home. Who pays for that? What if you have a non-exempt employee buying a printer? Is that company property? What are your policies on all of that? Because we also love to say to be consistent. It's our favorite word. So you want to have the policies because they keep you honest. So think about all of that if you haven't already done so. And lastly, pandemic-related harassment. The EEOC also, but I should mention, again, for all of you who want to read, the EEOC guidance, easy to find on eeoc.gov. It was updated on April 10th, so it's very current, and they talk about the confidentiality of records and a lot of the points that I've already made. And they also talk about pandemic-related harassment. So we've seen in the news, there are some people who may be blaming particular national origins for this and that kind of thing. I'm happy to say I haven't had a lot of those questions from my clients, and that's good. But you want to be aware that cannot be tolerated. I'm sure it's covered by your sexual and other unlawful harassment policies. If you don't have them, you should. But you want to, if it comes up, be reminding the employees about the company policy on that, because the EEOC will certainly not tolerate it. So I want to be mindful of time. We want to be we want to honor our time commitment to you. So we have 10 minutes left. A quick note before I forget, I'm going to go through some questions, but I did see a lot of questions about the PPP program. As you could tell from our slides and our invitation, that is not the topic of this seminar, although we have spoken about it in the past, and we will speak about it again. It's actually employment, but it's also tax and corporate kind of related. So those questions, I want to direct you to our website. We have a COVID resource center. If you go on there under events, we've taped all our webinars, and you can easily just pull it up and you can hear our corporate tax partners talk about the PPP program. And I think a lot of the questions that we see in our chat Q&A will be answered on those webinars. If they're not, or if you don't like that, just reach out to any of us and we will get you to the right place. Okay. And of course, I think if you go on the website, you can, if you're not already subscribed, you can subscribe so you automatically get those updates. We update almost every day, I think. Quickly, just some notes. Marissa mentioned a chart, a very good, we call it the scenario chart. It's on the, if you just go to njdol.gov, you can find it. We can give you the specific address if you can't find it, but it's pretty easy on there. It's called scenarios. Partial unemployment. There is a partial unemployment program in New Jersey for sure. It's called WorkShare New Jersey. They're developing it. I have to say, I don't think it's as developed as other states, but it's certainly available. There's criteria, and you can get more information about that on the DOL website as well. So this fear question, you know, one of the questions is, if fear is just based on fear, do you still have to accommodate? It's a good question. I mean, I think I would be cautious. I would be cautious as an employer and really try to work with the employee to work something out, if at all possible. Every case is different, so they're very fact specific. But I think it's a little hard to understand as an employer whether something is just fear or where it's coming from. So again, caution and flexibility are what we're hearing from the law, the government, and that's how I'm approaching these issues, at least for the time being. So some of these, like I said, some of these questions are a little fact specific. Bringing people back to work at a lesser rate. Again, very fact specific. Generally, yes. Depends on whether they were at a lesser rate when they went out. It depends on whether you're doing it across the board. Generally, if you don't have a contract with employees, you can adjust their rate, whether it's salary or non-exempt, prospectively. And I would be very careful to do it across the board. If you read the news out there, you could see a lot of that is already going on. Okay, so I don't know, Jamie or Marissa, if you see any questions that you want to answer in yours in our 6 minutes left. And by the way, we'll stick around for a few more minutes after if anybody wants to ask offline questions, and you can see how we're reachable.
Yeah, I did see, thanks Randy. I did see one question come up about the documentation requirements for tax credits for the FFCRA. And like I said, there is IRS guidance on this, but generally you are going to need the employee to certify that they cannot work due to the whatever reason they're using FFCRA leave for. And also, depending on the reason for using FFCRA leave, whether that's paid sick time or the expanded FMLA benefit, you may need additional information like the name of the school that the employee's child goes to, or the name of the government entity that issued the quarantine order. And especially for a huge note on employees using either paid sick time or expanded FMLA benefits for taking care of their child, that employee has to be able to certify that no one else is available at home to take care of the child. So in a situation with a married couple with children, if one spouse is home and can take care of the child, then theoretically that means that that employee may not be entitled to FFCRA leave because there's someone else at home who can kind of swap duties and take care of the kids and help out. So that's something to note, and to make sure you get those records from the employees to make sure you get the tax credits for any money you pay out. And I also did see a question as to whether this presentation will be available after. It is being recorded, and it will be on our website on that COVID-19 Resource Center Randy was talking about. So you can view it as often as you please.
Marissa, I saw a question about the age for the children for the expanded family leave. It's under 18, right?
It's under 18, but you are, for children that are 14 or over, the employee is going to have to say there are special circumstances why that they can't work to take care of their child, because the law is kind of assuming that a 14-year-old generally can take care of themselves at home, but there are of course special circumstances. And also there is the possibility that a child over 18 can be covered if there are, again, extenuating circumstances like a disability or something that would require that parent to be home with them and to be taking care of them and not being able to telework or work from home.
Great. Okay, well, we just have a few minutes left, so we want to honor our time commitment to you, as I said. Most importantly, we want to thank everyone for joining us. We've done a lot of these webinars. Please stay tuned. We will continue to do this, both in print and live, so to speak. And most importantly, we hope everyone remains healthy and happy as can be during these times. We'll get through this and look forward to seeing you all soon.
I would only add, Randy and Marissa, thank you for a terrific program. Our profiles are at the end of our slide deck, and our contact information, email addresses, and phone numbers. We are available. If we didn't get to your questions, or they're too fact specific for the program in general, please reach out to us. We'll be happy to answer any questions that we can.
Thanks, Jamie.
Thank you all.
Okay, thanks everybody. Take care.
Thank you all. Be safe.